Anyone can ask questions. Anyone can come up with a script for cross-examination. Anyone can perform the rudimentary steps of asking someone about their prior inconsistent statements. But the art of trial advocacy, the art of convincing a jury to believe you and to buy a narrative is something very different, and not a lot of attorneys do it well. Key elements of the prosecution's case against a Massachusetts woman accused of killing her police officer boyfriend began to take shape this week. Plus, a hip-hop trailblazer and music mogul heads to trial in a federal case alleging wide-ranging acts of sexual exploitation and trafficking. And new shocking insights into the moments surrounding the brutal stabbing deaths of 4 Idaho college students. All this and more this week on Courtroom Confidential. This week was absolutely exhausting, and all I'm doing is watching. There's a lot for us to get into. We are recording this episode on Friday, May 2nd, 2025, and this is your Courtroom Confidential weekly roundup. Let's jump in. In the first 7 days of Karen Read's retrial, the prosecution has shifted strategy by introducing new evidence and changing the order of witnesses, but the case continues to carry intense pressure and high stakes, as seen in the first trial. Read has pled not guilty to second-degree murder and other charges in the 2022 death of her boyfriend, Boston police officer John O'Keefe. Her first trial ended last year in a hung jury. Prosecutors say Read intentionally hit and killed O'Keefe with her Lexus SUV outside a fellow officer's home in Canton on January 29, 2022, after a night out drinking. Read's defense says she simply dropped O'Keefe off at the home and that someone inside the home attacked and killed him before leaving him in the snow. Earlier this week, Ian Whiffen, a digital forensic examiner with Celebrite, testified that John O'Keefe's cell phone never moved far from the flagpole at 34 Fairview Road, where his body was found. Whiffen also explained the timing of Jennifer McCabe's Google search, quote, "Haas long to die in cold," noting that there was a search for Hockomock sports scoreboard at 2:27 a.m., and the internet browser tab was left open. When the tab opened again at 6:23 a.m. to search for Haas long to die in cold, it was registered the same timestamp as when it was opened initially. Also this week, witness Jennifer McCabe took the stand. McCabe, a key figure in the first trial, testified that Read was hysterical when O'Keefe's body was found and recalled hearing her say at the scene, quote, "I hit him, I hit him, I hit him." McCabe, who was with Read and O'Keefe at a bar and later at her sister's house the night before his death, said she received a panicked call from O'Keefe's niece shortly before 5 a.m. on January 29th, saying he hadn't come home. The niece handed the phone to Read, who told McCabe she and O'Keefe had argued and she left him at the bar. McCabe volunteered to help search for O'Keefe, driving through the blizzard with Read and Carrie Roberts, another close friend of O'Keefe's. When searching for O'Keefe at his home, McCabe said Read pointed out her SUV's cracked taillight. McCabe went on to describe when they arrived at McCabe's sister's house and found John's body outside that Read was erratic and was, quote, doing a lot of screaming and yelling, and at one point asked her to Google hypothermia and how long it takes for somebody to die in the cold. During cross-examination, defense attorney Alan Jackson asked McCabe if she ever discussed testimony with Roberts. McCabe denied discussing testimony, but acknowledged they had spoken. Jackson challenged whether these conversations could have influenced their memories, an assertion that McCabe denied. Finally, Jackson asked whether McCabe told the grand jury that Read said, "I hit him, I hit him, I hit him." McCabe said that she wasn't sure. Quote, "I have testified a number of times, but I was there the morning of January 29th when your client said, 'I hit him, I hit him, I hit him,'" McCabe said. After court, Read told reporters McCabe was lying on the stand. Quote, "Every statement's different. Under oath, not under oath. This is very similar to what we saw a year ago." What's happening here? A lot happened this week. A lot of the pivotal pieces of evidence, pivotal witnesses, the real meat and potatoes of the prosecution's case all happened to take place this week. There's more to come, but really much of that evidence that we have heard about for so long, the Google search for how long to die in the cold, the "I hit him, I hit him, I hit him" statement, all of these things we were talking about this week. But in my view, if you had to point to a watershed moment, a turning point moment. It all comes down to the cross-examination of Jennifer McCabe done by Alan Jackson. This case really hinges on the jurors believing a certain narrative. And that narrative from the defense is not just that the Commonwealth cannot prove this case beyond a reasonable doubt. It's that these other people were in on it. These other people were involved. There's a conspiracy. It's not just the prosecution did a poor job. The prosecution can't prove certain elements. It's that, by the way, our client not only did not do this, we will tell you who did. And so therefore, when you have a witness like Jennifer McCabe, who the defense believes to be at the very intersection of all of that, the cross-examination of that witness will become a pivotal moment in this trial. And what we have seen demonstrated here is how trial advocacy really becomes an art. Anyone can ask questions. Anyone can come up with a script for cross-examination. Anyone can perform the rudimentary steps of asking someone about their prior inconsistent statements. But the art of trial advocacy, the art of convincing a jury to believe you and to buy a narrative is something very different, and not a lot of attorneys do it well. I think Alan Jackson absolutely is one of those. But what you saw here this week with the cross-examination of Jennifer McCabe really presented some difficulties for Alan. It was asking, how far can you go? How hard can you go on a witness, but knowing instinctually when it's too far, when it might be coming too much. In her role as a key witness for the prosecution, by default, is an enemy of the defense. And so they treated her as such. But my question is, does the jury know that yet? Are they far along in the journey with the defense to believe that this woman is an enemy? To believe that this woman, because remember, it doesn't just come down to credibility with her. It comes down to lying for her, at least as far as the defense is concerned. So these folks, these 12 jurors, these are people who purportedly don't really know anything about this case. They're not invested in this case like maybe some of you are and like I am, to have watched the first time around, to know these witnesses, know where each side is going. They may not know Jennifer McCabe and how important she is. So are they along for the ride? Have they come far enough along in the journey that the defense treating her like an enemy is something that the jurors can swallow? You can be aggressive with a witness. You can cross-examine them and have all the histrionics and theatrics that you want, as long as that witness has given you permission. And the jury feels that they have given you permission. Have they given you the rope to hang them with, is what I'm saying. Jennifer McCabe, especially when we compare her testimony in this trial, was, I think, much better, more reserved, more composed this time around than she was the first time around. And I think that frustrated the efforts of Alan Jackson to some extent. She was much more prepared for those gotcha moments, for how to handle prior inconsistent statements. And much of his cross, because he wasn't able to frustrate her, because he wasn't able to get the same types of outbursts and snark and really contempt coming from Jennifer McCabe, it frustrated his efforts to come after her as strongly as I think he would have wanted to. And therefore, I think some of his cross drifted towards splitting hairs and the minutia of how things were said at different times that she's testified, and if they were slightly different. Not every time someone testifies is it going to be exactly the same, and that doesn't necessarily register as lying. And I wonder if the way that McCabe handled herself took away some of that sting, stole some of his thunder. In the end, he got across the same points. He scored the same points that he needed to. He pointed out the same inconsistencies. But did it all have the impact on the jury that it might have had, or that it did, the first time around? In other words, did this jury end up believing that Jennifer McCabe was not just mistaken, but was lying? And that's why Allen was so aggressive. It's not just a question of good or bad memory with the defense. It's a question of honesty for them, a question of veracity, and they need to accomplish the task of making the jurors believe that Jennifer McCabe wasn't just mistaken, but was in fact lying. But what do you guys think? Who won the battle of Jen McCabe this time around? Please let us know in the comments. Sean Diddy Combs confirmed at a hearing Thursday that he rejected a plea deal from federal prosecutors in his sex trafficking case, clearing the way for his trial to begin next week. Combs has pled not guilty to charges of sex trafficking, racketeering, and transportation to engage in prostitution. His attorney, Mark Agnifilo, said his legal team reviewed the offer with him before deciding to reject it. Prosecutor Maureen Comey said the deal would have offered a lighter sentence than if Combs is convicted on all charges. Jury selection starts Monday. The court plans to seat 12 jurors and 6 alternates from a pool of 600 potential jurors. Agnifilo requested that jurors be asked if they read anything about the case since completing a questionnaire provided to them earlier, citing recent media coverage. The judge reminded both sides to avoid public statements that could prejudice the trial, responding to a defense motion seeking to bar lawyers for witnesses, including Douglas Wigder and Lisa Bloom, who represented people who have filed separate civil suits against Combs from speaking publicly during trial. Combs is alleged in the 5-count indictment to have coerced and threatened women to participate in sexual acts and silence them through blackmail and violence. Prosecutors allege he had help from a network of associates and employees. Jury selection is set to begin on Monday, May 5th. What's happening here? You talk to any trial attorney. I mean an attorney who's maybe even done one trial. The lesson you learn immediately is that perhaps the most important part of being a trial attorney is in picking a good jury. It's all in jury selection. If you don't pick a good jury, I don't care how good you are. I don't care how good your facts are. If you have a juror on that jury who is entrenched with a bias, you're going to have problems. You're never going to convince that person. How many cases have we seen that have hung by 1 or 2 jurors? Now, that could be people who genuinely came in with an objective, open state of mind and just were not convinced either way. But I think more often than not, you've got 1 or 2 holdouts, 10 people were convinced beyond a reasonable doubt, and 2 people felt no. Usually what you're dealing there is somebody who has an entrenched bias, somebody who was just never going to see things the way that you had hoped. And that may not even be apparent to that juror themselves. They may honestly be answering questions during jury selection that they don't have a bias, that they don't have any preconceived notions of this case, that they aren't going to entrench themselves into one point of view and never come out of that. Maybe they honestly believe that. So how in the world is an attorney supposed to discover that about this person in just a few questions? And now you're beginning to see why jury selection is so important and so difficult. But especially in a case like this, especially in a case dealing with celebrities, especially in a case dealing with someone who's just in the news every single day. So let's talk about what kind of jurors each side might be looking for. And I think it comes down to a couple of broad concepts and where different folks might fall on either side of these issues. The first is what I'll just call lifestyle. Are these jurors the type of person who can wrap their head around P. Diddy's lifestyle? Can they understand the parties and the lavish expenditure and the drugs and the drinking and the sex? Can they understand all of that being a part of someone's lifestyle with no criminal activity taking place? They're going to see videos. They're going to hear about these parties and how drugs were everywhere and people were having sex everywhere. And there was celebrities involved. And these things were just something that will never be experienced by most of these jurors. Things they may not even be able to comprehend, but can they wrap their head around it? Can they understand it as being something that does take place and doesn't involve criminal activity? Or are they so adverse to it that they believe it has to have involved some sort of criminal act, that it naturally indicates exploitive, illegal behavior just by the mere fact that it's taking place. I think that's the first thing that either side is going to have to discover from these potential jurors. The other thing is the idea of whenever you're dealing with a celebrity who's been accused of some sort of misconduct, especially sexual misconduct, and those allegations have taken place a long time ago, you're going to have to, and this is especially difficult for the prosecution, find those people who become naturally cynical that something else must be at play behind these allegations. That this is not an aggrieved person, a victim, who has kept their mouth shut for so long because of fear or because of the idea of having their name out there in the public, the idea of testifying against this person in power. But the reason that they've kept their mouth shut is because nothing really took place that was wrong, and they just want to take down someone in power. They're looking to take down a celebrity. They're looking to have their day in court. They're looking perhaps at an avenue that might lead to a payday or money for them. And some people do believe that. When they see an instance like this, a person in power, a person of celebrity, a person with money especially, and years later allegations are coming out, there are people who say, you know what? Something else is at play here. There's some angle that this person is trying to work. And that, I think, is going to be another thing that the prosecution, but both sides are going to have to be able to discover from these jurors. But what do you guys think? Here's my question for you. Do you think that you would be a good juror to sit on this case? Please let us know in the comments. An Idaho judge has again rejected efforts by Bryan Kohberger's defense team to take the death penalty off the table in the 2022 stabbing deaths of 4 University of Idaho students. Kohberger is charged with killing Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin in an off-campus house in Moscow in the early morning hours of November 13th, 2022. Idaho recently became the only state to designate the firing squad as its primary method of execution, a law that takes effect in July of 2026. Meanwhile, newly released court filings shed light on the final hours before the killings. Prosecutors introduced a string of texts sent between 4:22 and 4:26 a.m., in which the 2 surviving roommates said they were scared and freaking out after one of the roommates reportedly saw a masked man dressed in black outside her bedroom. Judge Stephen Hippler largely granted the prosecution's request to introduce the texts, and in doing so offered new insight into the hours immediately before the texts were sent. According to the filings, all roommates except Kernodle were back at the house at 2 a.m., gathered in Gonzalez's room discussing whether to get food. Ultimately, the group decided to stay in and went to bed. Around 4 a.m., a roommate described by only the initials DM said she woke to, quote, strange noises and crying near the bathroom. She opened her door and saw a man in black with a ski mask and bushy eyebrows. Running to another roommate's room, she noticed Xana lying on the floor of her bedroom with her head towards the wall and her feet toward the door, initially assuming she was drunk. It was not until 11:56 a.m. that morning, the other roommate with the initials BF called 911 and told the dispatcher, quote, something is happening. Something's happened in our house and we don't know what. Judge Stephen Hippler later ruled that part of that 911 call will be redacted from trial, including a line from a female voice saying, quote, oh, and they saw some man in their house last night. Yeah, agreeing with the defense argument that it included inadmissible hearsay. In another recent filing, prosecutors revealed plans to present surveillance footage at trial. Footage and the resulting timeline, they argue, point to Kohberger as the lone suspect. Investigators canvassed the Moscow neighborhood around the King Road residence where the students were killed, collecting security video from more than 20 locations. The next hearing is set for Monday, May 5th. Court documents do not specify what it will be about, and the hearing will be closed to the public. Well, what's happening here? I want to talk a little bit about the behavior of the surviving roommates and how that behavior has fallen under a lot of criticism online and in the media. And I really feel that it is unfair. You have to not put yourself in the position of these two surviving roommates. You have to put yourself in the mind of who they are at the time this is taking place. It's not how would you have acted and how would you have responded under these circumstances. It's how would someone their age, young folks, still in college, intoxicated, living a lifestyle where there are people coming and going from their home all the time. They're coming home at 2 o'clock in the morning and talking about going out again to get more food. They're not living the lifestyle that many of us, many of you listening and watching this are. So I think that needs to be considered when we are trying to understand how they're responding and why they were acting the way they were that morning. But also something else, and this is something that we all share, and it's this natural desire for us to not believe or refuse to believe that when something is happening, it could actually be our worst nightmares taking place. If I heard a bump in the night, I might not act the same way as these two surviving roommates did. I might respond differently. I might go investigate more than they did. I might call 911 just after hearing a strange noise in the house. But I don't think that I would immediately jump to the idea of some horror taking place in my home like these young people did. So the idea that the next morning they're not sure what happened, the idea that they still have not gone to check on their friends, the idea and all these questions that you see swirling around online, yes, it's mysterious, and yes, it's bizarre, and yes, you may not have behaved that way, but it does not necessarily mean that these people deserve that suspicion and criticism. Remember this, and this involves every single case. Every single case will have mysteries and curiosities and unanswered questions. But not every mystery and curiosity is necessarily a conspiracy or even grounds for suspicion. We talked about jury selection before, and I'll talk a little bit about it again now. When I was a prosecutor, I would stand before jurors and say, listen, I intend to prove to you beyond a reasonable doubt every element of the crimes charged in this case, but I can guarantee you, you are all smart people, and you put 12 of you together, that there's no way I can answer every single question that will come into your heads. There is no way that I can bring resolution to every single mystery and curiosity that may take place in the normal course of events. But these questions, these curiosities, these mysteries do not add up to reasonable doubt. And that is something the prosecution is going to have to deal with in this case. But what do you guys think? What mysteries do you guys see in this case? Please let us know in the comments. Hey everybody, before we jump into the other cases making headlines this week, I'm only going to ask that you do me this one very small favor, and that is, if you haven't already, please take a moment to subscribe to this channel now. We want to continue to provide you with the highest quality content that we possibly can, and the best way we can do that is through your support. And don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, a Florida judge has granted another continuance in the long-anticipated trial of a grandmother alleged to be the mastermind behind a plot to kill her son-in-law. On Thursday, Judge Stephen Everett granted Donna Adelson's defense team's request to delay her murder trial, which was set to begin on June 3rd. Adelson, who attended Wednesday's motion hearing via Zoom, is charged with first-degree murder, conspiracy, and solicitation in the 2014 killing of her former son-in-law, FSU law professor Dan Markell. Defense attorneys argued that they needed more time to review recently obtained wiretaps and more than 80,000 emails in addition to discovery related to jailhouse informants, including whether any received favorable treatment in exchange for testimony. Markell was shot in his garage in a murder-for-hire plot. Adelson's son, Charlie Adelson, was convicted of hiring 2 hitmen to carry out the killing. He is now serving life without parole. One hitman is also serving life. The other took a plea deal. Charlie's ex-girlfriend, who acted as a go-between for the Adelsons and the hitman, is also serving life. Donna was arrested shortly after her son's conviction in November of 2023, and shortly before she was set to take a one-way flight to Vietnam. Judge Everett also announced on Wednesday a May 16th deadline for filing motions and ordered prosecutors to turn over remaining discovery related to informants by this Friday. A South Florida entrepreneur awaiting trial in the disappearance and murder of his estranged wife in Spain has died by suicide in federal custody, his lawyer confirmed Monday. David Knezevich, who faced charges including kidnapping resulting in death, foreign domestic violence resulting in death, and the foreign murder of a U.S. citizen, was accused of killing Ana Maria Haneo Knezevich, who vanished from her Madrid apartment on February 2nd of 2024. Her body has never been found. In a brief statement, defense attorney Jane Weintraub said the legal team was devastated by the news. "We trust that a thorough investigation into his death will be conducted," she added. Knezevich was arrested in May of 2024 at Miami International Airport. Prosecutors said he traveled to his native Serbia in January of that year amid a contentious divorce and financial disagreements with his wife. Once there, officials say he drove a rental car to Spain, where his wife was residing, and shortly after kidnapped and killed Anna, carrying her body out of her Madrid apartment in a suitcase the evening of February 2nd. "This is all a big tragedy for my sister and family," said Anna's brother, Felipe Haneo. "We had the naive hope he'd come clean and tell us what he did with her. Now that's not going to happen." This week, a Texas judge denied a motion to dismiss the murder indictment against a San Antonio man accused in the disappearance and presumed murder of his wife. Brad Simpson has been in custody since October 9th, days after his wife Suzanne Clark Simpson mysteriously and suddenly disappeared. At issue was a narrow challenge to a specific portion of the indictment, which the defense argued was too vague. Quote, "If you're going to allege an act clear and dangerous to human life, they need to know what that act is," said defense attorney Stephen Gilmore at an April 22nd hearing. Prosecutors countered that the lack of a body should not prevent them from moving forward with the charges. Quote, "We don't have a benefit of a body for a medical examiner to examine, but that doesn't prohibit us from filing the case," said prosecutor Casey Sandoval. The defense is now seeking to access all witness testimony and evidence presented to the grand jury that indicted Simpson before setting a trial date. One of the two teens convicted in the infamous Slender Man stabbing case has had her release date delayed once again after a judge found an issue with the proximity of her proposed housing to her surviving victim. Morgan Geyser, now 22, was convicted in 2014 alongside Anissa Weir after attacking their sixth grade friend Peyton Lautner under the delusion that the fictional character Slender Man told them to kill her. At a Monday hearing to finalize her conditional release, prosecutors objected to the plan, noting Geyser's intended group home is just 8 miles from Lautner's current residence. "We have a large problem," Waukesha County Assistant District Attorney Ted Sopakowicz said. "The entire state of Wisconsin, Judge, and we have a plan that has her 8 miles away? The authors of the plan never consulted with the victim in this case," he continued. Lautner's mother, Stacy, told the court her family was very concerned, adding, quote, "Peyton has worked incredibly hard to heal from the profound trauma she endured. She deserves the right to engage in everyday activities, such as grocery shopping or visiting the library, without the agonizing fear of encountering the individual who held her down and stabbed her 19 times when she was just 12 years old." Judge Michael Boren ordered officials to find an alternate placement within 30 days. Geyser is due back in court for a new release hearing in early June, making this the third time her release has been delayed. 3 former Memphis police officers were frustrated, angry, and full of adrenaline when they fatally beat a man to death, a state prosecutor told jurors Monday during opening statements in their trial for second-degree murder. Tadarius Bean, Demetrius Haley, and Justin Smith were all previously convicted in federal court for their roles in the 2023 beating of Tyree Nichols, which was captured on surveillance and body-worn cameras just steps away from Nichols' home. The video shows officers pepper spraying, chasing, and brutally beating the 29-year-old Nichols as he cried out for his mother. After showing video of the beating, prosecutor Paul Hagerman told the jury that a severely injured Nichols sat on the ground while officers failed to tell medical personnel that he had been hit multiple times in the head. Nichols died 3 days later from blunt force trauma. In his opening statement, Bean's attorney argued his client responded only after Nichols fled a traffic stop, claiming the encounter turned high risk when Nichols resisted arrest. Quote, "He was actually resisting the whole time," said attorney John Keith Perry. The officers are charged with second-degree murder, aggravated assault, aggravated kidnapping, and official misconduct. Two other officers, Emmett Martin and Desmond Mills Jr., are expected to change their not guilty pleas in state court, according to lawyers involved in the case. Sentencing for all 5 officers in the federal case is expected after the state trial concludes. After the lead prosecutor stepped down against an OnlyFans model accused of murder, her attorneys are now asking the court to disqualify the entire Miami-Dade State Attorney's Office. Courtney Clenney is charged with murdering her boyfriend, Christian Obumseli, in their South Florida apartment. She claims she acted in self-defense when she threw a knife that killed him. Prosecutors previously pursued charges against Clenney's parents, accusing them of illegally accessing Obumseli's laptop. Those charges were dropped after a judge found the prosecutors had violated attorney-client privilege. Now Clenney's attorneys say the breach of attorney-client privilege runs deeper than previously believed. Former lead prosecutor Khalil Keenan stepped aside after the defense discovered he had reviewed and circulated a privileged document titled Courtney Checklist of Things to Do -privilege.docx, which was sent to Clenney by her attorney and later obtained via a third-party records request. 2 new prosecutors, Sean Abahoff and Kathleen Hogue, have denied under oath that they reviewed the document. But in a motion filed shortly after an April 30th hearing, Clenney's defense team argued their statements do not insulate them from disqualification. The judge will hear arguments on the disqualification request on May 22nd. Clenney remains in custody and no trial date has been set. Before we get to what's on the docket for next week, I want to take a moment to thank you all for being a part of our growing Courtroom Confidential community. But I wanted to give a special shout out to Hippie Goddess for their fantastic review on Apple Podcasts, as well as to our CC crew members Vesper Martini and NH6 Central for their support on YouTube. Please keep them coming. We absolutely love hearing from you. And please tell us where you're from. We are thrilled by the growth of our Courtroom Confidential community. On the docket for next week, Michelle Peters, a Missouri woman who faces charges of first-degree domestic assault and armed criminal action after allegedly spiking her husband's Mountain Dew with a chemical weed killer, will be in court on Monday, May 5th for a pretrial hearing. Accused Appalachia High School shooter Colt Gray will return to court on Tuesday, May 6th for a status conference. Gray is facing 55 charges, including multiple counts of murder, aggravated assault, and cruelty to children in the 2024 shooting. The federal case against Matthew Farwell, a former Stoughton, Massachusetts police detective accused of killing Sandra Birchmore after grooming her for years, is expected in court on Tuesday, May 6th for a hearing. Shanna Gardner and her estranged husband, Mario Fernandez, who are accused of plotting to have her ex-husband, Microsoft executive Jared Bridegan, killed in 2022, will be back in a Florida court on Wednesday, May 7th for a case management conference. The former tight end for the San Francisco 49ers, Kevin Ware Jr., who was charged in connection with the death of his girlfriend, Taylor Pamaski, will be in a Houston court on Friday, May 9th for a pretrial hearing. Eric and Lyle Menendez, who were convicted in 1996 of murdering their parents, Jose and Kitty Menendez, in 1989 and sentenced to life in prison without parole, will be in a Los Angeles court on Friday, May 9th for their resentencing hearing. And finally, please join us on YouTube this Sunday for our special question and answer series, Sunday Fun Day. All are invited to leave a voice message at thecourtroomconfidential.com, which we will answer during tomorrow's live stream at 9 a.m. Pacific, noon Eastern. And that is it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.